Chief Justice chooses otherwise. Dr. Justice Shremsai, how do you respond to what you have heard from lead defense counsel on the Edubwahin case when he says that I wasn't in court today because it's legal vacation?
Certainly, that is what it is.
I see. I have the Deputy Attorney General here who has written that, look, the legal vacation is not for lawyers. The legal vacation is actually... So just so I understand, you're saying that your absence today is in defiance of the CJ's orders, that certain cases should be heard during the legal vacation, correct? And I should be resting.
Thank you very much. The question is not whether counsel is tired.
Actually, judges' vacation and not for you lawyers. And no lawyer should be telling the Chief Justice that they need to rest. And so some cases should not be called. When the Chief...
The way to a TV between Akyea, the lawyer Akyea, no, the Deputy Attorney General, in fact. So I'm part one and can't share and can't answer. But once I watch a video from WhatsApp, not a wide conversation straight to the news. Now, Nancy on Cherry, it could be a month from what did about this legal vacation now, man, for no want to well, since an Akyea and coming in any. Why are there? Yen where the legal vacation. And then no more from Poko school or other for vacation will be a homogeneous bill. But Sir Judge is so about the case to da or do Pepe do be other ones also watch one home cacra. There, Obey Akyea wants also to win ya home for. Now, one conference a win ya Poko one coin will two know which church one who are manager will two know what I bought to the mother. But oh, yeah, then yena, and I know you read them come about that judges no Boko vacation. Oh, yeah, them. NDC aban pede wo fa attorney general do wodi chinchi amanfo bu yi wonse wodi gu nature Akyea de kan da masari Akyea na asam no kan ye simple osna edubu ahin nye sebe obi wewie Ghana maniska obi botum aka de o edubu ahin wewie Ghana maniska sebe cases oro kodo wo Ghana mayimi cases nyepa na oro kan wanse wonyina de ya within Ghana we Ghana fo na sir judge but na asam da na sir judge no wo boko vacation abadinti no there sebe oye attorney general obey adopt them now also no pokwa there onya ne yo e wonu pokwa anya ne yo but mo ne yo ye there the fact there NDC communicators are making it look like if the MPP for one na jama bi awore sebe ya not too long ago Akyea kade onya zo base court as a lawyer no akobo on the client not because of the order no pedo but to tell the attorney general there nyono no oba hihye mrada mobi okroma ha na mbrano before attorney general baba no it was already made and they invited deputy attorney general there counsel be about some attorney general rekano in fact deputy attorney general wan fano hu afen kasa tenten ena woma akonya there Akyea ankan komo na bi in fact at that Akyea the year papa no it was terribly shocking because also there I am a lawyer. Judge original home lawyer yin so muso magima home so it's nyina no ye peda ma be no na nyina de kupchechwe yan. We thought there people in the international space were going to support this and make NDC look as if they are doing the right thing, but none of these international organizations are even supporting the NDC. Akyea is becoming more and more right in front of the face of many people because when we're there, the lawyer Akyea is more smarter, more intelligent, and maybe a man for no, it is making sense to them. And then I say NDC, you should always get it right in your mind today. Dama and Yama Kofi worry, it is not going to help our Ghana.
So just so I understand, you're saying that your absence today is in defiance of the CJ's orders, that certain cases should be heard during the legal vacation, correct?
Certainly, that is what it is.
I see. I have the Deputy Attorney General here who has written that, look, the legal vacation is not for lawyers. The legal vacation is actually judges' vacation and not for you lawyers. And no lawyer should be telling the Chief Justice that they need to rest. And so some cases should not be called when the Chief Justice chooses otherwise. Dr. Justice Shremsai, how do you respond to what you have heard from lead defense counsel on the Edubwahin case when he says that I wasn't in court today because it's legal vacation and I should be resting?
Thank you very much. the question is not whether counsel is tired or not. If courts were run based on the tiredness of individual lawyers, you can imagine what would happen in a democracy. So whether counsel is tired or not, no one can take that away from him. The issue is whether a court proceeding should continue simply because counsel says he's tired. And that is where we are of the view that the tiredness of counsel or counsel's private circumstances need not determine whether a case will be heard in court or not. Now, secondly, there are situations where lawyers may have genuine reasons why they cannot come to court. And it may even be true that tiredness may be one of such reasons. But the solution to that problem is not to say and sit in your office and say that you will not attend court because of legal vacation. If a counsel has a problem or is tired, what counsel needs to do as far as the professional law practice is concerned is to appear before the judge and make a case for an adjournment based on the circumstances. Then the judge will consider your plea, and judges have always done that, whether in term time or in vacation. Judges always consider counsel's circumstances in adjourning cases. And I can say on authority that I'm in a couple of cases with my good friend who is the defense lawyer here, Lawyer Atta, where adjournment has been given, where proceedings have been cut short because of his personal circumstances, where he needed to attend meetings, where he needed to attend to family reasons, adjournment has been secured. So to create the impression that it is because he's tired that he doesn't want to come to court would be a wrong way to look at the issue. Now, secondly, counsel, I understand him to be saying that it is only his case or some specific few cases that are scheduled to be heard in the vacation. That is completely false. And you see, that is a deliberate twist of the facts to create an impression that a system has been set up to persecute some particular individuals. The practice of having cases heard during legal vacation is as old as the judiciary itself. It begins from England, and now we practice it in Ghana. It is something that we've always done. And if you follow what conversation is going on, there is evidence that judges from 2011, for instance, Chief Justice Georgina Wood has actually asked commercial court to sit throughout the vacation. Mm-hmm. There are instances where the previous Chief Justice, so it is a normal thing. The impression being created that some persons are targeted is completely false, in the sense that, you see, there are a number of vacation judges. Oral cases are not before only these judges. There are oral cases in other courts. Those courts, the judges in those courts are not appointed as vacation judges. Therefore, those cases are suspended because the judges are not. And in respect of these judges, they do not only do oral cases, they conduct other cases, like he's mentioning. Some of them conduct robbery, rape, and other cases, and those cases too are ongoing. So
that, just to get the point straight, what you are telling us now is that the legal vacation is not being used to hear only high-profile cases.
At all.
So there are regular cases being heard in certain courts, not interlocutory, but substantially.
Precisely.
Okay, right. Yeah. And then it takes me back to the defense counsel in the matter of Kwabena Dubois in court. Counsel, you left your client in a bit of a pickle when you decided that you will not go to court today. What we are learning is that you could have gone to court and then put in a plea with the judge that you needed that needed to be accommodated before then leaving the case. Why wasn't that an option for you?
Because I have petitioned the CJ. The decency of engagement is that it's the CJ that gave the warrant to the judge to continue with the case. So the judge should have stayed in hands and to hear what the CJ will say. That's the decency of everything. You see, so the judge cannot say, okay, I've not heard from the CJ, although it's petitioned from the CJ, but I'm giving you next week, come and do your own case. Please, we should stop this kind of, engagements. so that people will turn around and say somebody is showing disrespect to the judge or whatever.
Perhaps
so who gave the warrant? The CJ. The lawyers have petitioned against the warrants issued by the CJ. Shouldn't we say that let's abide the outcome of the determination of our petition to the CJ and the case should continue? So how can a lay person cross-examine a witness, the prosecution witness? It's such a critical case. How is that going to be done? Are you not subverting his right to counsel? And when counsel
how is that subversion of right to counsel when it's you that did not show up in court?
You see, sometimes I love to scorn when people believe that lawyers do not have the right to challenge what authorities say. I am not running away from the court. There is an aberration I'm fighting. I do not see how some cases are not slated. The Honorable Stramsa was even given an impression that there are cases that they are doing part heads. You should name the cases. Aside these special ones, that the judges are ready to do part head cases. If people have learned cases, and in the wisdom of the rules of court, we should go on legal vacation. What is the superiority of preference? Now let's do these special cases. And the land cases and the murder cases should go to bed until October. That is selective justice that the Constitution frowns upon. It's obvious. What is special about these cases? What is the emergency about these cases? That they can't abide our return from vacation, everybody's refreshed and we continue. You're giving everybody an impression that, look, these cases are of priority to you. Why should some cases be of priority to the CJ and not others? This two-track system in which some cases are of no consequence but others matter to the CJ undermines totally the rule of law, and we got to challenge it. Not that anybody is running away from the case. I've been very faithful. You talk to the Attorney General in the prosecution of this case. I've never absented myself once. I've never been to the hospital. He will testify. I'm not running away from my favorite area, litigation. So what is the point? But what is the emergency about this? They can't explain.
We'll have Doug look at that. But before we go to him,
I will not violate the traditions of the practice that we are clear that we should rest, but we are giving oxygen to especially arrangement in which some people who have been arraigned before the court, not on interlocutory matters. You rightly said it, but on full trials that continually is unfortunate.
Let's go back to Doug on the matter of urgency of the cases, because besides you making the assertion that this is selective justice, because you do not believe that regular cases are being heard substantively, the AG has said that is not the case. You're also raising the matter of what is the urgency about these particular high-profile cases that need to be heard during the legal vacation. Doug, what's your response to that?
Yeah, thank you very much. It is unfortunate that even after I have informed counsel and assuming that he didn't know that there is no special treatment for these cases, other cases in these vacation courts are being tried and heard. He still goes on to insist that, to say the thing that he has no knowledge of, which is also not true. So clearly, I am convinced that the purpose of these issues, the purpose of doing what counsel has done is not genuine. It is to perhaps just use this to achieve other purposes. For example, one of the things that we learn in law school, okay, as ethical, is that a lawyer, when you are representing a client, should not avoid the courtroom and use other means to delay court processes. But that's what is happening. Look at what the situation is. There is a date for hearing. It was determined when court when the date was agreed. Now, you have written a petition to the Chief Justice, and your argument is that until you hear from the Chief Justice on your petition, you will not go to court. But is that how it is done? Even we know that even when you apply for stay of proceedings, until it is granted, the case continues. So on what lawful basis would counsel say that he decided not to go to court because he's waiting the decision of the Chief Justice on his petition? The right thing, as far as my understanding of practice is concerned, is to appear before the court. And even when you go to the court, you can still tell the court that, oh, because I have made this application or this petition to the Chief Justice and I've not heard from him, can you indulge me to hear from the Chief Justice? That is what we are taught to be done. But to refuse to come to court and say that because you have taken some other process and you have not had an outcome, so you will not appear before the court, I'm not sure that is what, as the second person who leads the bar, I'm not sure that is what I would recommend as a proper or a good way of representing a client. And I think you are very right when you said that his decision to not attend to court is what is making his client suffer. And I think that is exactly what it is. If you have anything, and I have always maintained that judges throughout the country are reasonable people, even in term time. We all go to court and we sometimes ask favors or basically give reasons why cases should be adjourned or should even be truncated because of our personal circumstances. And I can tell you, judges most of the time will accommodate that. Counsel on the other side will accommodate that because we are human. What this case is presenting is to put the decision whether a case should continue in the hands of a lawyer to decide that I will not come because I think that I am not supposed to come, which is not what the situation should be.
I'll have Counsel Akyea respond to that. But while you come on, gentlemen, I just want to say that we have heard from the Chief Justice on this matter. He's upheld his earlier decision to call certain cases during the legal vacation. I want us to take a listen to the Chief Justice, and then Counsel Akyea, you respond to that briefly for me.
Okay.
To write to the Chief Justice to say that the cases should not be adjourned to the vacation. So I am not coming. I have already made arrangements outside, so I'm not coming. You are a lawyer. You have your clients. If your clients decide to give you leave, well, go on leave. But you cannot say that there's a legal vacation and the judge who is actually sitting cannot do your case. No, that's not it. And then adjournments are not at the instance of the Chief Justice. An adjournment is a judicial act. This is something that is so basic that sometimes when people write that I got a letter saying that I should withdraw the directive and also direct that the cases should be heard in the same time. I said, you went to court and the judge decided that she was right.
Counsel, you heard him. He's very clear.
It's not clear to me at all. But you can tell me, what is he saying?
Well, he says that, first of all, that instance is the instance of adjournment does not come up onto him. But he's also said that you cannot say that lawyers need to go on vacations, though the judges shouldn't work when there is work to be done. Essentially reiterating what Doug has been telling us this whole time.
No, why are all the courts not working? Why are some special courts working? It's not selective justice.
No, but
what discretion is that? That some cases are very special to the CJ, and therefore let's all rush to court and do them. The rest of the cases don't matter. Let's all rest until we come to October.
How is that your conclusion? When we have agreed that cases being heard during legal vacation is not new. The example of Justice Wood was given when commercial cases were heard during...
What commercial cases are part-heard and being continued? Let me know. What are the commercial cases that are part-heard? Do you understand part-heard cases? And can you fix part-heard cases in vacation without agreement of the lawyers? Is the judge sitting by himself or herself without the convenience of the lawyers? What is the meaning of legal vacation? Even the linguistic evidence is telling you that we are on vacation.
But you've been told that the legal vacation is for the judges, not the lawyers.
The Court of Appeal is on vacation. If you want to have judges sitting, it relates to emergencies. So you bring a motion, and even now it's virtual. What is special about these part-heard cases? That at all costs they should be heard, at the great inconvenience of the practitioners. We don't have to rest. For what? What is the basis of that? Is it not in violation of the Constitution? So I don't understand what is going on, but you see, I don't have to come to court and persuade any judge that, well, I will not be able to continue with the case. Let me hear from, the CJ. I've stated in my letter to the CJ, copied to the registrar of that court.
Right. So Counsel, here's another angle you haven't looked at. Why are you not in a hurry to clear your client's name?
Who tells you I'm not in a hurry to clear my
Well,
client's
you've been
name?
given an opportunity to work during this
period. The whole
period.
year I've been working.
Say that again.
I told you that the whole year, when was the time that I said I won't come to court? And you believe that I shouldn't have my vacation as the CJ is having his vacation? What is the meaning of legal vacation? If you want to go and read the law, go and pay regard to Order 79. And Order 79 decrees legal vacation. What is the meaning of legal vacation? When a studio is on vacation and you say that, oh, there are some special cases that they should come in here, you should justify it. What is special between what a murder case and Kwabena Dubois' case? Why are the murder cases not being heard?
What will be justification enough?
What will be justification enough? Somebody's pleasure, unquestionable pleasure, a fetish of a pleasure, that these are special cases by my own thinking. The rest of them, they don't matter. You think we can't question discretionary powers, administrative decisions? They are all embedded in the Constitution. Yeah. What are you feeding the public? Why? Why are we in an ambulance mood to try these cases? The rest of them don't matter. What is the point of the matter? That lawyers should not rest because to the mind of the CJ, these are special cases that should be heard. What is the point of that? I don't understand that.
The judge says in 6 days you should be in court, or Kwabena Dubois without legal representation will represent himself. Do you plan to go to court on August 17th?
I'm not going to court at all. But what is informing that? Why should a judge in a very technical case of this nature, that a man's lawyer is on vacation and the judge is saying that if your lawyer doesn't come, go and find another lawyer. But he's saying that you come and stand there and cross-examine. How can a lay person, cross-examine in such a matter? You are asking a carpenter to go and do a surgery.
Then go to court.
It's not. Sorry?
Then go to court.
For what? For what? Why should I go to court? What is the meaning of legal vacation? What is special about this case? Some of these things you are failing to answer. And I know they can't answer. What is special about these cases? When we try these cases in the vacation, the inflation of Ghana will go down. What are we saying? What is the emergency about these cases? They can't answer. The other cases are of no consequence to the realm. These are the specialized ones that we should hurry them. What is the point of the matter?
Let's get to Dag on this, because there's another issue I want us to look at, Counsel, just before we wrap up on this conversation. Dag, what is special about this case? Why in a hurry to see the end of this case? Why can't we just let the legal vacation pass?
Thank you very much. I'm just looking at the legal vacation court roster. Okay, so there's a whole list of courts and judges who are supposed to sit during the vacation. And I just counted, and there are 31 judges sitting throughout Ghana during the legal vacation. Greater Accra alone has about 11 judges sitting as legal vacation. So why is counsel insisting that it is only these two cases that he is handling that are for legal vacation? So the judge sitting in Bongatanga, Tamale, and Tema, are they all doing his cases? So I'm getting a bit frustrated by counsel's posturing. It is when we started, I just assumed that he probably didn't know that there are other judges sitting and hearing cases. But when you don't know and you have been informed, I think what you do is to change your position, but you keep reminding him, and he keeps repeating the same thing that he said from the first question you asked him. That's what is so special about these cases. But the evidence on record shows that there are other cases being heard in as many as 31 courts throughout the country. So clearly, there is no basis for these complaints. And the allegation that there are some cases that have been specified as ambulance cases it is neither here nor there. Now, let me even explain something about this particular case, the Dubois case. Before the legal vacation, the court made it clear that there's only 1 day left for counsel to complete his cross-examination, which he has been cross-examining for almost 3 months. So the court said, you have 1 more day. That was before the vacation. Now, if counsel was in court today, he would have ended the cross-examination, and guess what will happen? The case would have been adjourned for him for 2 weeks or more to file his submission of no case. Then after that, the prosecution will be given another at least 2 weeks to also file our response. Then after that, the judge will adjourn for additional 2 weeks or more to give his ruling. Then after that, if the ruling goes in favor of counsel, the case ends. If it goes in favor of the prosecution, then he will be given 3 more weeks to file his witness statements, and then additional time before before we go to court for CMC. So, technically speaking, in counsel's case, today would have been the only day that he would be required to be in court. All the other processes would have been done without him being in court way up to like November. So you see, the point we are making, it is not about counsel's tiredness. There is a deliberate effort, I believe, to have some auxiliary effect. Now, the same counsel who says that he is tired and cannot work is the same lawyer who has applied for bail for another client in another case. And so it is even difficult to believe that there is some genuine tiredness or some genuine issue here. Because when you need a bail for your client...
Well, we cannot come to that conclusion.
Well, I mean...
We cannot come to that conclusion, but he's here. Let me take some of the issues that you've raised to him. And counsel, now that you have heard...
I'm hearing very embarrassing things from my Attorney General.
How do you mean?
Yes, let's be very clear in our mind. You see the way you are going on, as if you are the judge, that somebody is going to finish his cross-examination today, as if you understand what is going to go on. Please, you don't know what we are also doing from our end. You understand? You wish we would curtail our cross-examination so that one day they will say that he didn't cross-examine in this area. It is deemed admitted, as was said in the Wontumi case. So please leave us to conduct our case. But let me come to a very interesting dimension, which is very sad. How many of the vacation judges are trying murder cases and they are continuing? In the Tamale High Court, go and find out whether the judge is trying a case of a land issue which is part head. So please don't confuse interlocutory matters with substantive trials and adjudication. We don't have it that way. This is the first time that we are seeing a situation in which lawyers have not agreed.
I'm not sure that's what Doug has said, but I'll have him respond quickly to that. I'll come back to you, Counsel.
So this is the thing.
Saying that,
the Chief Justice says something in
Counsel, hang on for me. I want Doug to respond to the issue of interlocutory cases and substantive cases that you have mentioned.
Because the bail application is making an issue about
the Chief Justice says something.
Yes.
Please, am I on the line?
Yes, we can hear you, Doug.
So the Chief Justice says something in his explanation. He said he doesn't control adjournment, and that is correct.
Oh, what
does that mean?
We've lost Counsel, hang on. We've lost the connection to the Deputy Attorney General, but I believe he's back. You finish that point quickly for me because I want Counsel to finish his thought process as well.
Okay, so I'm saying that the Chief Justice said something. As to which proceedings to take, those are judicial decisions that every judge is entitled to take. The Chief Justice, what he can do is to give a warrant for the judge to sit. As to whether the judge decides that this is the number of what we call interlocutory matters out here, or this is the number of substantive matters out here, those are matters that the judge himself will be able to handle. And that is why it is imperative that counsel will appear in court and make a case. But to sit at home and say that because it's legal vacation, you won't come to court, then how do you expect the judge who is sitting to even understand that you are tired or give a reason why you are not able to do X, Y, Z? So the whole thing is bizarre to me.
Very well. Let's go back to counsel so counsel can make his point on this matter. Counsel.
It is sad you think I'm tired. I'm upholding the principle. I'm not tired. As I'm talking to you, I'm in my law firm. You understand? I'm not tired. But there's a principle which is embarrassing the justice delivery system. Now we have selective justice. Some cases will be heard. substantive matters. And if I apply for bail, you know that it's according to the vacation rules that the circumstances of the matter require that emergencies can be attended to in vacation, but never cases which are just parted. There's nothing emergency about a parted case. Nobody's going to take a ship out of the jurisdiction. You can come by ex parte application to arrest the vessel. So please, let's know the difference.
Counsel, here's my thing. Your need to uphold the principle of the Convention of Legal Vacation, does that supersede you attending to your client in court today and then on August 17th?
You see, I will not violate the traditions of the, what's it called, the practice because of the pleasure of the CJ. I'm telling you this, it's very important. Then we should delete from Order 79, we should delete Order 79 of CI 47. So we don't have what? Legal vacation. I'm giving you linguistic evidence that we call something legal vacation. And let me read to you Rule 1. Subject to the Courts Act, 1993, Act 459, amendment, the Chief Justice may appoint any day, including vacation, for the hearing of causes or matters as circumstances require. So the circumstances required here are the emergency circumstances, not part heads. I've been around for over 30 years. I've never seen what we are talking about. That you want to compel a lawyer to come to court and come and do a part head case. And when it's not an emergency case, when you are applying for bail, is it a part head case? It's an emergency case that somebody is languishing in his awam. You want to see whether the judge will consider an application for the individual to be admitted to be pending appeal.
Counsel,
so
what now?
Is aware of the difference. And don't confuse people into believing that in Tamale, there are high court judges who are doing part-head rape cases, manslaughter, part-head cases. They don't do part-head cases in vacations. What they do, they deal with interlocutory matters of emergency nature. So I am not tired.
But Counsel, remember, he's also explained that when it is at the behest of the Chief Justice, you can do both the interlocutory and substantive matters. He's explained that already. But I want us to focus on you and your client. I wonder how your client feels about the threats that was given him today and the fact that you were not in court to represent him, and the likelihood that you will not be in court on August 17th to represent him because you are upholding the principle of legal vacation. How does he feel?
He feels very, very comfortable with me, you know. He believes that I'm a very principle-centered lawyer. He believes that I won't shortchange him. And he's not in any ambulance mood to cross-examine as a lay person, a prosecution witness. We are not little boys in the game, madam. I'm telling you what we believe as a principle. How can a judge tell, a carpenter to become a dentist and remove somebody's tooth? How?
So what's next? What happens going forward?
We will advise ourselves. We will not begin to put our legal arsenals in the public space, but we'll advise ourselves. We know what to do.
What does advising yourself and knowing what to do mean?
We will not be compelled to go to court, for Christ's sake. This is not the first time that we've had the Chief Justice, I'm afraid.
Gentlemen, I want us to look at other issues. But Counsel, you know, in court today, your client told the judge that you were out of the jurisdiction, which means where are you now?
I'm in my law office. I'm not out of the jurisdiction. I don't know.
Your client lied to the court.
My client ever said that, because we spoke this morning and he knew I was in Ghana.
Oh, but our correspondent tells us that he had told the judge you were out of the jurisdiction. Doug, am I wrong?
I don't know
about that. He didn't say it as a fact. He said he believes. He believes that the lawyer is out of the jurisdiction.
Oh,
but he didn't say
matter
of fact.
Oh,
right.
Goodness me. I'm surprised. Yeah.
Thank you.
I'm here. I've not gone out of Ghana.
Very well, gentlemen. So I want us to look at the Untumi bill hearing today. What the Attorney General's office has said is that, look, not only are the reasons you put in your affidavit not reasonable enough for any chance of success, But also, your client is a flight risk. And the reason they say that is because his former counsel has said on a media platform that, but for his own advice to Chairman Wontumi, he would have left the jurisdiction of this country. How does this come to you?
Well, I believe this, as cathedral issue should not be part of the thinking of any serious judge. As a matter of fact, I do not know the validity of this matter outside the court. But a man is a flight risk, and 9 good months, he never absented himself in court. He came to court. Wontumi was faithful to the hearing of this action for 9 good months. So what is it? What is it? This business of is a flight risk? So please, I would rather you spare us, this discussion in the media space regarding a very valid application I've filed. And let's come to court. I've not received the affidavit of opposition from the Honorable Attorney General's office. But if I should get it, I know what to do. But for anybody to now begin to raise, extra legal matters, it leaves much to be desired. It will be very, very unfortunate and dangerously prejudicial to what we are about to do on the 19th.
Very well.
And on the 19th, we are not going to do a part head. It's an interlocutory matter. I was glad you used that expression, interlocutory. It's not a final thing. Nobody's going to adduce evidence. And probably you might even do it virtual. That is the point of the matter. And that's the difference between
I will risk it and ask Dag a question as well. And Dag, feel free to have your final comments on the conversation around legal vacations. But when in that affidavit, the Attorney General's office puts that you thought that Chairman Wontumi will be a flight risk if he's released on bail based on third-party information. Why is that important to you?
As important to me?
No, that's for Dag. It would appear his connection to us is frozen. Doc, did you hear me?
Sorry, I didn't.
Very well. So I was just saying that you could have your final words on the conversation around the legal vacation. However, I'm also risking a question, or based on the affidavit I have read regarding the opposition to Wontumi's bill. And my question is why the acknowledgement of a comment his former counsel made about he wanting to leave the jurisdiction at some point in time is important information to you as you oppose it, considering it is not first-hand information you have gathered, but it's based on someone else's narration.
Dominic, can you please do me a favor on this one? Since this matter is yet to be heard in court, I would beg that I do not comment on it. The issue we have been discussing on the legal vacation appears to be a general issue rather than the specific matters of a particular case. So if you can kindly assist me and excuse me from commenting on this particular aspect.
Very well.
I think it will become obvious why the position is made in the affidavit. Now, my last comment on the legal vacation issue. I think the place for every lawyer to fight for their client is the courtroom. If a lawyer is tired and wants an adjournment or wants a special consideration for his personal circumstances, I believe the place to go to is still the courtroom. So I would encourage my good learned friend to try as much as he can to understand that vacation courts are not only for his clients' cases, and they are generally for everyone, and he should appear in court. And perhaps if he makes his concern known to the judge, and he is very, very, very persuasive in his legal matters in courtroom, and I believe he will be able to persuade the judge to grant him some few days to have his rest and to serve the interests of his client, because personally, I am not happy with the situation where a client will be left in court without counsel that he has duly hired. So I will encourage my learned senior to appear in court and perform his obligation towards his client and to the court.
Very well, counsel. And if on the 17th, the case is called nobody from Zoe, Akyea, and co. represents a Dubois in court, and for that reason, the judge decides one of two things: have a Dubois represent himself, or discharge the prosecution witness from cross-examination. What then?
I know what to do.
To me or to my
to counsel.
I respect the advice coming from the elegant, honorable Deputy Attorney General, but I also know what to do.
Very well, gentlemen.
I know what to do. I know what to do when a judge is saying that a carpenter should remove a tooth, not a dentist. I know what to do.
I wonder what that means. I know what to do.
Yeah, so pour it in your heart. I know what to do.
Very well, gentlemen. Thank you so much for your time on this subject matter. Thank you very much for your insight as well. I appreciate your time here with us on the Daily Brief.